Hi, everybody. We're going to go ahead and get started here with our third panel. So it is my privilege, truly an honor, to introduce this panel. This is the one that I've been most looking forward to. So we have three really great panelists today. We have Professor Brandon Beck, who is currently teaching at Texas Tech Law School. He received his JD from Texas Tech Law School, and he is a legal writer, an appellate advocate, and expert in federal criminal law. He's argued 15 cases before the Fifth Circuit, including an argument before the en banc court, and he was actually appointed as Mr. Rahimi's appellate attorney in the case that is pending before the Supreme Court and will be argued on Tuesday. Before that, he was before being a professor of law, he was an assistant federal public defender, a civil litigator, the editor-in-chief of a literary journal, a graduate student in history of ancient religion, and a high school math and Latin teacher. So that is Professor Beck. And then we have Ms. Kelly Roskam, who is the Director of Law and Policy at the Johns Hopkins Center for Gun Violence Solutions. She studies the constitutional implications of and advocates for works to improve the implementation of firearm laws. Previously, Ms. Roskam was General Counsel for the Coalition to Stop Gun Violence. She earned her BA from the University of St. Thomas and her JD from Penn State Dickinson Law. And then we have a donor here with us today. That is Mr. Jason Medinger. He is the chief of the criminal division and the chief of the appellate division of the United States Attorney's Office for the District of Maryland. Mr. Medinger earned his BA summa cum laude from the University of Notre Dame and his JD with Order of the Coif from Emory University Law School. And our moderator today will be Professor Jimmy Gurule. He is a professor of law here and the director of the Exoneration Justice Clinic. He's an expert in the field of criminal law, international criminal law, terrorism, and terrorist financing, as well as national security law. Professor Gurule has worked in a variety of high-profile public law enforcement positions, including as Undersecretary for Enforcement, U.S. Department of the Treasury, Assistant Attorney General, and Deputy Chief, of the Major Narcotics Section of the U.S. Attorney's Office for the Southern District of California. And among his many successes in those roles, Professor Gurule was instrumental in developing and implementing the U.S. Treasury Department's global strategy to combat terrorist financing. So, looking forward to this panel, and I will pass it over to Professor Gurule.
Okay, thank you. Thank you very much. The way that we're going to be proceeding with this panel is that we're going to proceed in the following order. First, we're going to hear from Mr. Medinger, and then Professor Beck, and then Ms. Roskam. I'm going to ask each of you to hold off on asking any questions until each of the panelists have completed their remarks. I'm going to ask the panelists to limit their remarks to no more than 15 minutes, because I want to make sure that there's plenty of time after the formal presentations for Q&A from the audience. And so I'm honored to be moderating this panel on a very important topic, and litigating under Bruen. And as is previously stated, this is the practitioners panel. So each of the speakers is going to be coming at this issue involving firearm gun regulation from a practitioner's and policy perspective. And we have three very unique perspectives. So we're going to have, first we're going to hear from Mr. Medinger, who's going to give us the prosecutor's perspective. Then we're going to hear from Professor Beck, who is going to give us the criminal defense lawyer, public defender perspective, in light of the fact that he worked as an assistant federal public defender. And then we're going to hear from Ms. Roskam, who's going to give us kind of both a policy perspective, but also speak to some of the work that she's done in filing amicus briefs on important cases involving gun regulations. So with that, I'm going to turn the first 15 minutes of time over to Mr. Medinger.
Great, thank you, Professor, and huge and ardent and sincere thanks to the Notre Dame Law School, the Notre Dame Law Review, and the Duke Center for inviting me here. I'm honored to be here, as Lexi said, as a donor. I'm so elated to be back here on campus. Go Irish. Thank you for having me. What I want to do is divide my remarks into two phases. Phase number one is the practice, where we get into the trenches, the meat and potatoes of what my daily life is like post-Bruen. And it is a great one. It is a day of full employment for an appellate lawyer. I will always be employed because I get to keep fighting these issues, and I find them fascinating. And the second part I want to talk about is the practical, in terms of can we look from a 30,000 feet view, where are we going? And what does this mean for society? What does this mean for our laws, for positive laws on the books? Where are we going? And what impacts, if at all, should that have on how we litigate these things? So first, jumping into the practice, I'll give you just a snapshot of what it's like to be an assistant United States attorney these days. We charge many individuals with gun crimes. Felon in possession is a bread and butter crime that we charge, so that's 18 U.S.C. 922 G1. It's someone that has a prior felony, and they're not supposed to thereafter have firearms or ammunition. And so we charge many of these. We go into the grand jury, we get our indictment. We arrest the person, they come in for an initial appearance, then we have an arraignment, and then immediately thereafter, I get a motion to dismiss, saying that everything that we've done heretofore, all the investigative efforts, are a nullity because we've charged an unconstitutional crime, and that even felons or any of the other prohibited persons, they had a constitutional right to have that gun. Government was wrong to take it from me. I am now wrongfully imprisoned. I'm imprisoned under an unconstitutional law, which is a very unique challenge. Interestingly, these motions come in, they're normally 1 or 2 pages. Normally they cite Bruen, and they use the word unconstitutional, and then they sit down. And the reason they do that is because, as a couple of the panelists pointed out, I think Mr. Willinger pointed out, Bruen does put the onus on us, the government, to come forward with showing no, these actually are quite constitutional laws and these are fine. So really the onus is then on us, and I then go and prepare our response. And to do that, I turn to a number of sources, but thanks to the Duke Center, there is a large compendium of ancient gun laws, which is very helpful. Law Review is very, very helpful, so all the academicians out there, thank you for cataloging that for me, and for those that write books and treatises. We go to those, but we try to put a record together for the court, and then we litigate these things. But during the process of all of that, I've identified 4 problems, and I want to talk with you about them because some of the talks and papers have discussed them, and I really want to put them in a granular focus. And the reason why I want to get granular is because, one, I hope it'll bridge any divide that might exist between academicians and practitioners, to narrow that gap so that the scholarship that's coming out will hopefully be the kind of scholarship that can move cases and that can move us to more clarity. But additionally, maybe some academicians out there will take pity on a poor government attorney and want to be a pro bono expert in some of these areas. But anyway, so the first problem that we have is what I'll call the record-making problem. And that essentially is, how does one find laws that were on the books in 1791? How does a very busy assistant United States attorney go out and find these things? And yes, there are some good resources out there, but they all come with some caveats. And one of the ones, I'll be honest, that I struggle with quite a bit is the trust problem in the record-making problem. In other words, you could see a law review article that says X, Y, and Z, but unless you consult the actual source yourself, as a practitioner, as an officer of the court, as somebody who needs to stand up and stand behind what you're saying and every word of it, how comfortable are you? We've heard a little bit of discussion today about how people disagree with some of the history. So you can cite, Law Review Article A saying this is exactly the historical practice. Maybe Law Review Article B says just the opposite. And so what do you do as an advocate? Do you go back to the original sources? I think you should. But how do we do this? I told you that motion to dismiss comes in normally the first day after the arraignment. Under our local rules, we have 14 days to respond. So you think about that time window. Yes, we can get extensions of time, and we often do. But the project that was described about the one county in North Carolina took an academic semester. And so we have to sort of condense that into 14 days. And if we don't do it, that statute is potentially gone. But ultimately, we want to get to the right answer. That's certainly my goal. And so when we're doing this record-making problem, we have to, I'll just say it, I think we have to do better in terms of finding the historical sources and doing a better job of making our record. But the onus is on us to do it, and we have a very short fuse in which to do it. The second problem that we encounter is what I call the context problem. And it's something that's been alluded to, but it's even if you get to the source, even if you find a Rhode Island statute from 1791 that says, drunkards can't have pistols, even if you find that law, do you have the appropriate context, though, to understand it and to know how it was enforced, to know, frankly, sometimes they use verbiage, and do we really know what that means? Even if you get a Webster's dictionary from the time period, are you actually understanding the words that Webster is saying? The one example that I'll give you, which is kind of has some resonance for here, we've been fighting the sensitive places doctrine. And one of the places that we've been fighting about is the National Institutes of Health in DC, and can you proscribe guns? And so I found very interesting laws on UVA's campus. UVA in 1820s, Thomas Jefferson was still alive at the time. He was on the Board of Visitors, and obviously he was a signer and involved in these laws when they were coming out. And so UVA, they banned guns for students on campus. And so the question is, why did they do that? And footnote 2, Notre Dame today under Duloc still proscribes guns on this campus. So there's a little bit of a history of universities doing this. But again, why did they do it? Did they do it for public safety? Did they do it because students were rabble-rousers? Did they do it because maybe students were not, they're going to be students and not part of the militias? I think a lot of times we lack a lot of context to be able to speak authoritatively on these issues. Interesting, the University of Georgia had the same thing. We cite it as an analog, but is it really? And that's some challenging questions that we struggle with. The third problem that we have is what I call the precedent problem. And I think, Professor Miller, you discussed this a little bit. The idea of once a court decides an issue regarding gun laws, what happens next? So assume in the District of Maryland, a judge reaches a ruling. Let's say we drop the ball, we don't create a sufficient record, and you now have a positive decision saying that 922G1 is unconstitutional. In most district courts, they're very wary to create intra-district splits. And that makes sense in the sense you want all people in one jurisdiction to be treated the same. So if it's unconstitutional as to one person, it's going to be unconstitutional as to another. But so you see the snowball that happens. So even if Judge A didn't have the right record and reached a result that was going to find something unconstitutional, Judge B is going to be very, very reticent to revisit that. And you see it actually in the cases that Professor Beck was involved with some of the with the Daniels case. There was a lot of decisions from Western District of Oklahoma, Northern District of Texas, all affirming the constitutionality of this. And a lot of those judges sort of fell in line with their fellow judges, and then all of a sudden Daniels comes out, and all of those now are going to be washed away. But you saw the effect intra-district. And so again, it puts a pressure on us to say, well, is it precedent or is it not? In other words, we're doing what I would consider to be a facial challenge to a statute, but we're really doing it under an as-applied record. In other words, if I make a good record, okay, but it's going to be very challenging for us to sort of undo if we lose some of these. So that weighs on us quite heavily. The fourth problem that we've identified is what I call the opaqueness problem. And this was, Professor Blocker talked about this, and I think Professor Siegel, the idea of what Bruen said, we have a, we need to have an analog, not a twin. And so if you look at that as a spectrum, twin being over here, complete nullity, I guess, being over here, where's that cutoff? Where is analog in that spectrum? And I'll give you an example of that we struggled with, and we'll see which way it comes out. It's with regard to obliterated serial numbers. So all firearms have to have a serial number on the gun. That's current federal regulation. It helps with tracing with the initial sales of guns. When you purchase a gun, you have to make a lot of averments to say, you're not a felon, you're not using it for an inappropriate purpose, et cetera, et cetera. You're not a straw purchaser, things like that. So the question was, is that constitutional post-Bruen? And so the historical record, as you might imagine, is essentially non-existent because putting serial numbers on weapons really didn't start until 1910. I think Smith & Wesson was one of the first ones to sort of start doing it. So it doesn't have that 1791 pedigree, so what do you do as a practitioner? Well, we found some things that were close. They were like it. They were sort of driving at the same purpose. So one of the examples we found was in the 1780s and 90s, you would have to register your firearm with the local township. So if Jason Medinger owned a gun, I would have to go to the township of Towson where I live. I would have to say, yep, I've got a musket. And I think the purpose behind it was to say if we do have to muster a militia, Medinger's in. Or or if we're going to train our people, he's available. And so we said, well, look, it's maybe not a twin, but it is somewhat of an analog. Because the whole idea of a serial number is we want to know what guns are going to what people. And actually in the 1780s, they kept ledgers that said which people had which guns. Therefore, serial numbers are okay today. The judge agreed with us on that one. It's currently on appeal to the Fourth Circuit. So anybody's guess as to how that's going to come out. But just last month, I think it was the Southern District of Ohio or Northern District, one of those ones, completely disagreed with it and said, as a matter of fact, serial numbers didn't start until 1910. That's it. That is where I'm stopping my analysis. And I would argue that that's a little closer to the requiring a twin than it is to the analog. And they'll be fighting that, I'm sure. But you see sort of the struggle. And so how opaque do we get? How far away from a twin are we okay with being? And that's something that we really struggle with in the practice. So those are the four problems. We have been litigating these, frankly, with much success. But Rahimi is coming out, and Rahimi has the chance to re-scramble the board. So who knows? Once again, full employment. So that sort of ends the first part of my remarks, and that's the practice. I'd like to just also briefly touch on the practical, because I think certainly here in an academic environment, we need to discuss where are we going with things. I think we are very focused on Bruen, its test, what did it say, the great scholarship that's being done to dig into these historical sources. All of that is wonderful, but let's step back as a society and think about, can we have gun regulations? Can we? I think these cases sort of ask the question, but I want to put it in a little bit of a practical frame. And that is, every year we prosecute between 300 and 350 individuals. Probably half of them are charged with gun crimes. And principally the folks that we are targeting are folks that are capable of even more violence. So principally if you look at one of the prominent gangs in our area is MS-13. It's a Salvadoran gang. They often do amazing atrocities. And the 922G charges are actually great charges even if you can't get the racketeering events, or if you can't find the body that they hacked up and stashed, if you find one of a MS-13 member with a gang, you can prosecute that individual. And so that's another way to sort of quell violence and try to disintegrate the gang. You know, and so the question is, do we want to not have that tool in our toolkit? Do we want to just say as a society, that's just off limits for legislation? And is that where we're going? Similarly with regard to government facilities. So again, I mentioned the example of NIH, we're fighting that one, but think also about NSA or the White House. You know, is that the kind of space that we're comfortable going on the White House tour with someone next to us with an AR-15? And I think, you know, there's debates on how this idea should impact our litigation, if at all. There's some in the camp of the, to quote a Latin phrase that I'm sure Professor Beck will like, fiat justitia ruat caelum. You know, let justice be done though the heavens may fall. In other words, if it doesn't comport with originalism, the statute falls, that is the end of the story, we don't care anymore. But there's also, you know, another side that looks at, you know, normative values. And I think Professor Siegel talked a little bit about that, of should we be considering those. And, you know, those are for smarter people than me to decide that, namely justices of the Supreme Court. But I do think it's helpful in this debate to take just one step back and try to think about, well, where are we going? If we go down the route where Rahimi is going to win, what does that leave for the rest? And I think we can kind of see a little bit where that might go. And do we have space to legislate here, or do we not? And is this an individual right that leaves really very, very little room to maneuver? So we'll see where it goes. I will say in the trenches, it is a very exciting, exhilarating time. Again, I appreciate everyone's perspectives here, and I thank you for your time.
Thank you, Jason. I think I've written down like 6 questions that I'm going to ask you during the break, but I'll restrain myself. Next, we're going to hear from Professor Beck. Pleasure.
Well, first I want to just thank everybody for putting this together and for having this. Thank you to the Duke people. Thank you for Notre Dame Law Review. And then also thank you for all the people that have presented here today and submitted the papers ahead of time. I read all of the papers and I really learned a lot from every single one of them. So I've complimented some of you personally on kind of how it's helped me, and I wanted to just do that publicly to everybody. One of the sayings I believe in is that if you're the smartest person in the room, you're in the wrong room. So I think that perhaps I'm definitely in the right room today, and happy to be here with you. I want to talk a little bit about my experience, how I got involved in some of these cases, and then touch very briefly on my perspective looking at it, which perhaps is different than some of the other perspectives in this room. I've only been teaching full-time for a very short period. Before that, I was an appellate attorney with the Federal Public Defender's Office for about 8 years. I was in the Northern District of Texas, which includes Dallas, Fort Worth, Amarillo, Lubbock, Texas, and then a few other smaller towns. And the Northern District of Texas is quite unique in 2 ways. First, it's one of the highest volume districts for federal prosecutions of all crimes. And second, at least in fiscal year 2021, it was tied for the most number of federal firearms prosecutions. So just coming through our office were so many gun prosecutions. And that's kind of how I started to get involved in all of these cases. In 2019, I argued and won United States versus Davis at the Supreme Court. Striking down part of the definition of crime of violence from a very common federal firearms statute called 924C. Then, a couple of years later, or even less than that, I was appointed in a case called United States versus McGinnis. And that was kind of Rahimi before Rahimi. It was a 922G8 prosecution. And that's when I started to get kind of really deep away from some of the vagueness and then away from some of the categorical approach stuff I was doing prior to that, and really start to focus in on this kind of post-Heller Second Amendment interpretation. And in working on that case and looking at some of the dissents and concurrences among the circuit courts, kind of starting with then Judge Kavanaugh's dissent in what's called Heller 2 that was mentioned earlier, you start to see kind of this groundswell of mostly kind of conservative judges and justices that are starting to look at whether the circuits kind of got it right when they were interpreting Heller and how we go about evaluating constitutional challenges to some of these gun crimes. You saw a growing support for this text history tradition approach away from means-in scrutiny. And so I really started to develop that working in McGinnis. I know a lot of people made the observation earlier. I really wasn't that aware of it at the time, but probably got a lot out of reading some of the articles that some of you had written before I even knew who some of you are. So I've been learning about it for some time, grateful to be meeting you. But that's when I worked on McGinnis. I argued McGinnis at the Fifth Circuit, and it was the first kind of case where the Fifth Circuit considered it. Ultimately, the Fifth Circuit decided that they were perhaps bound by a prior holding applying means-in scrutiny. Yet, before the panel, 2 of the 3 judges wrote a concurrence saying, we think we need to revisit our methodology, revisit our approach to evaluating these sorts of things. I moved for rehearing en banc in McGinnis, and the court was equally divided, so rehearing wasn't granted. Then the Supreme Court denied cert. That was a time when Justice Ginsburg was still in the court. It seemed clear that Justice Roberts wasn't on board with changing anything. And so there wouldn't have been enough support at that time at the Supreme Court to change the methodology. I spent the next year or year and a half trying to find kind of a similarly situated defendant to re-raise some of these same arguments. Ultimately, I came across Mr. Rahimi, who was prosecuted in Fort Worth, Texas, in the Northern District of Texas, assisted with the trial attorney to preserve these arguments at the trial level. Preservation, as we just heard, is a big part of what we do, often in the form of a motion to dismiss the indictment early on. And then was appointed on the appeal at the Fifth Circuit. I filed the appellate brief, but conceded that we have to lose under McGinnis. The only way the Fifth Circuit can change its own law is through sitting en banc. They adhere to something called a rule of orderliness that I think probably all circuits adhere to. So then I moved for rehearing en banc. While the case was pending, while that motion was pending, the U.S. Supreme Court issued its opinion in Bruen. The Fifth Circuit then automatically sua sponte vacated the panel opinion and set it for oral argument and requested supplemental briefing. I did the supplemental briefing before the Fifth Circuit, and it was right at that time I made the wonderful decision to leave the office and give the case to someone else. So I went to teach full-time, and one of my colleagues, Matthew Wright, who's going to be arguing on Tuesday, he got involved in the case, and his first involvement was presenting the oral argument in Rahimi. From there, we felt pretty sure that the government was going to move for rehearing en banc at the Fifth Circuit, and then we realized when that deadline passed that it was going to go in a different direction. The government sought cert straight away. They had actually done the same thing in Davis in 2019, so we had seen that before. And unlike when we seek cert, where we've got far less than a 1% grant rate, the government has about a 70% grant rate seeking cert, last I saw. So last summer, the Supreme Court granted cert in Rahimi, and we've spent kind of ever since then starting to think about the brief writing process. Of course, we're respondent, so it's hard to kind of write the brief straight away. But we did a lot of the research as much as we could beforehand, and of course, we knew some of the arguments the government would certainly need to make in the case. Once the government filed their merits brief, and I'm skipping over the whole brief and opposition stage, there's a whole middle stage to all of this. We spent the last several months writing the respondent's brief, and so we turned that in a while back. The government just filed their reply recently. And my friend Matthew is arguing it on Tuesday, so I'm going to go up there and support him. And I know that makes me, to a certain extent, kind of the bad guy in the room, and I'll acknowledge that, and also say that I'm not here to persuade anybody of my position. I do want to talk, just touch very briefly on kind of where I'm coming from. You know, coming from this high-volume federal firearms prosecution district, you know, what we see, if you were to look up on Westlaw, and I don't know if it's true or not, but according to Westlaw, I filed 410 appellate briefs with my name on it, mostly at the Fifth Circuit. A very significant percentage of those are federal firearms prosecutions. So of those 410, probably 300 of those people are still in federal prison, many for the mere possession of a firearm. And that's an important distinction that I think some of the headlines often miss, is that particularly the 922G offenses are almost universally felon in possession and almost universally for the mere possession of a firearm. Anytime you see the misuse of a firearm, as you also see, at least in the form of allegations against Zaki Rahimi, the Supreme Court case will not affect any of those charges. So he's facing significant charges in state court for every single time he ever pulled the trigger, every single time he ever laid a finger on anyone. The federal case is on his possession of a firearm. So my perspective on this case is not one as a gun libertarian. In fact, I don't own a firearm. I don't like being around firearms. I'm one of the people that walks out of the restaurant when someone walks into the restaurant with a firearm. But what I think about a lot is mass incarceration and the number of federal firearms prosecutions and how that number has increased significantly in the last 30 or 35 years. So I wrote an article about this called The Federal War on Guns, not from some sort of NRA perspective, although I know the title is kind of provocative, but really looking at the history of executive branch enforcement of federal firearms statutes, how that's changed, and then starting to talk about perhaps why it's changed. So when I think about these cases, I think about all of my clients who are in prison for possessing a firearm, many of whom have never laid a finger on anyone. Yet they're now punishable by up to 15 years in prison, thanks to an amendment to the statute signed by President Biden. And at least last I checked, in fiscal year 2021, we're prosecuting at a higher rate than we ever have in our nation's history. And so I wanted to just kind of share my point of view on these types of things, not to persuade anyone. I know that this is a very difficult topic and it's personal, and I'm sure that we're going to hear more about that, and I share those concerns. I have 3 small children. But there's a competing interest that maybe isn't talked about as much in the literature, and that's how it affects defendants who have admittedly committed a crime. But when we see a tool that we can use to push back on what I see as too much federal involvement in criminal law, I see that as a good thing. I say that with all the qualifications for all the reasons you've heard here today, but I did want to kind of share the defense perspective on that point. So thank you very much.
We're really doing great on time, so that's wonderful. Next, we're going to hear from Kelly Roskam.
Well, thank you so much to the Notre Dame Law Review and to the Duke Center for Firearms Law. I find myself being, despite somebody who's worked in gun violence prevention and firearms law for over a decade, maybe being the most out of place person at this conference. Because while I do actively follow Second Amendment litigation and firearms law, I also sit squarely within the policy development and advocacy space. And so I'm going to briefly discuss sort of the scope of the work that I do at the Johns Hopkins Center for Gun Violence Solutions, and also discuss the ways that Bruen has impacted that work. So as I mentioned, I work on policy development, I work with a really fantastic group of gun violence prevention advocates as well as public health researchers. And together we work to develop different types of gun violence prevention policy. Perhaps the most well-known policy that we've worked on developing are extreme risk protection orders, sometimes called red flag laws, which allow law enforcement and also sometimes family members to petition a judicial officer for the entry of a civil order temporarily prohibiting somebody at risk of harming themselves or somebody else from having access to guns. I imagine that we're going to see and are seeing already an increase in litigation on that particular policy. We also work on different various types of policy, including firearm removal, both in the case of extreme risk protection orders, but also domestic violence protection orders, public carry, firearm purchaser licensing, community violence prevention, and safe storage. So the way we usually do this is by building long-form reports, detailing the available public health research about the scope of the problem and the effectiveness of various different types of interventions. We'll also propose various different types of recommended language for different policies. And then my particular area in the development of these reports is how does this fare under the current legal framework for a variety of different challenges, particularly Second Amendment challenges. This was, I won't say easy, but maybe a little more straightforward under the two-part test adopted by courts after Heller. And I think very uniquely natural to the other part of my work, which is advocacy for these policy recommendations. So I will either draft wholesale or provide key advice to legislators on how to craft particular policy. You may be dismayed to find out that I've had my hand in the writing of almost all of the extreme risk protection orders that have passed since California's gun violence restraining order, for better or worse. Although not being a legislator myself, I have some limited influence over what ultimately makes it into those laws. But in that part of advocacy, the old two-part test really dovetailed very well with what policymakers are primarily concerned with when they're thinking about adopting gun violence prevention policies, which is, what is the problem that we're trying to address? And does the proposed policy actually affect that at all? Which of course works very well with means-end scrutiny. So in the wake of Bruen, some of the changes that we've started to make in policy development as well as advocacy is, what changes might Bruen wreak on some of these policies? What are the things that we'll have to keep in mind? And one of those things that comes into stark relief for me with what I assess myself to be a particularly unclear new test is, does it matter that the policy at issue is effective at reducing gun violence, intimate partner violence, or are we really talking about how it regulates the right and why, with no connection to the real world impacts of the policy? Which is a particularly interesting place to be in as legislators and voters are still very concerned with those things, and now have the added question of, how will this fare when it is inevitably challenged in court? And if I am a legislator in a not particularly safe district, who may be challenged in a primary or lose in a general election by going out on a limb and supporting this policy, would I still do so in the very unclear wake of this new Supreme Court case, where perhaps under Heller I would be reasonably confident that it would be upheld by the courts? I'm no longer confident, and in fact I can almost guarantee that if I support it, I'll have one court over here saying, yes, this is still constitutional, and I'll have another court over here saying, this is an absolute violation of Second Amendment rights. And it's certainly something that I don't envy legislators having to determine whether they'll move forward with a policy that our public health research tells us will absolutely save lives. And then a certain area of my work that continues on, but I'm not really certain how is impacted by Bruen, is implementation, which is something we haven't touched on quite as much here at this conference, but critically important to us, which is something that seems very obvious, but laws are not self-executing. So I think there was a time where we would pass a law and we'd pat ourselves on the back and say, what a great job we've done. We'll move on and get this policy enacted in the next place, only to find out that systems actors who are necessary for the implementation of the law are not doing what needs to be done to effectuate that. And I'll talk particularly in the context of domestic violence protective orders, since that's what we'll be talking about next week and probably for months and months to come, parsing the tea leaves and making predictions, is that all 50 states have civil domestic violence protective order systems. Many of those include prohibitions on possession and purchase of firearms. Fewer include clear instructions for respondents on how to relinquish those firearms, to whom they must do it, within the time frame it must be done, and who is responsible for ensuring compliance. Is that law enforcement? Is it the court that issued the order? Or, much more common, is it the protected party who has to return either to the court or to law enforcement to say, my abuser was ordered to not possess firearms, and I know he's got them, and what are we going to do about it? So several states have taken a great deal of initiative. I'll highlight Seattle, King County in particular, which has established a multidisciplinary regional unit to ensure compliance. Their courts hold compliance hearings within a time frame after the issuance of an order. Both law enforcement as well as somebody from the prosecutor's office or city attorney's office is often present at those hearings, having done some advanced reconnaissance to determine if that person is in compliance and to really help out on those matters. So we'll continue to work on that. TBD, how Bruen will impact implementation. Perhaps I think most obvious is the willingness of those system actors to enforce the laws that perhaps they now deem individually to be unconstitutional under Bruen, which was frankly a problem after Heller anyway. And finally, we've done a much greater degree of work on amicus briefs over the last couple of years, particularly after Bruen came out. So the first big brief we worked on at the Center for Gun Violence Solutions was a Seventh Circuit case called Miller versus Smith. It had to do with regulations on firearms in-home daycares and in foster homes. And this was particularly significant to us because I think we've spoken about this briefly at this conference. What is the role of both empirical research and public health research in the Bruen framework? I've seen courts absolutely dismiss the idea that they need to think about it at all, salutary policy goals and everything. And other courts that find that it simply comes in a different place and in a different way. So in the context of that case, we were trying to urge the court to identify in-home daycares as just like regular daycares held in places of business to be sensitive places, analogous to schools where vulnerable populations, children, come to learn. And what the public health research tells us about why children are so vulnerable in schools and in homes, particularly because there are many homes where guns are stored unlocked, loaded, and unsecured, and that often children, despite being taught not to touch them, know where they are naturally curious, and likely to harm themselves or somebody else with them. In addition, we filed a brief in United States versus Rahimi. I'm sorry, Brandon. Well, I do not think you are the bad guy. We have definitely been trying to make arguments around some of these ambiguities in the test, as the previous panel noted. How we define a modern or persistent societal problem can sometimes be outcome determinative. And some courts are identifying that as domestic violence writ large, although it's still an open question to me if cultural change constitutes the identification of a modern societal problem. If we didn't think it was particularly problematic at the time. But again, the fact that firearm intimate partner homicide was incredibly rare at the founding. In fact, intimate partner homicide in general at the founding was incredibly rare due to some cultural factors like the necessity of having a partner to maintain your home or farm and help take care of your many, many children, but also that firearms were incredibly unreliable, less lethal and less likely to be on hand. In addition, sort of this question around how closely to analogize to history. One point in particular that I take umbrage with from the Fifth Circuit is this identification of historical laws, disarming dangerous people, but identifying the purpose as the preservation of social and political order. And as we talk about courts not having sort of this interdisciplinary background, I think the Fifth Circuit would have really benefited from understanding the dynamics of domestic violence and its impacts on society much more. The Fifth Circuit took what I would consider to be a very outdated understanding of domestic violence as something that occurs exclusively within private homes, between private parties, and affects no one but those two individuals. What we understand to be true is not only does it impact a lot greater number of individuals, the most common corollary victims of intimate partner homicide are new partners of the victim of domestic violence, but also children, extended family, acquaintances, and also strangers. My colleagues at the Center for Gun Violence Solutions published a peer-reviewed paper which found that 68% of mass shooters either murdered an intimate partner or family member as part of that mass shooting, or had a documented history of domestic violence. I also think it deeply overlooks the role of women in society today, the idea that the loss of that individual does not in and of itself impact social and political order, such that they're no longer active participants of that. So I've gone on for quite a long time, and I'm not known for brevity, but I would like to leave quite a lot of time for students and audience members to answer questions, and so I'll leave it at, it is a really exciting time to be working in this space. Gun violence is a really terrible problem in the United States. It does not impact everyone equally. It has been my over a decade-long goal to remedy that. That's not going to change. But it would be really nice for the rules of the road to be a little more clear. So that when I speak with legislators or when I develop policy or when I write a brief, I'm not using my best guess or making the argument that I want to make rather than the argument that I should be making. So with that, I will conclude and open it up to Professor Gurule.
I'm going to take the prerogative of the moderator and ask the first two questions, and then we'll open it up to questions from the audience. I think we have a really unique opportunity here to raise some questions about Rahimi, because we have Professor Beck, who has intimate knowledge, both factually and legally, regarding the case and the issues. You know, he studied this case probably as much as anyone. And so I'm going to ask Professor Beck, I'd like the other panelists to comment as well, but I'm going to ask Professor Beck to remove his advocacy hat, because now he's a member of academia. I'm going to ask him to place his academic hat on and to highlight for us, you know, maybe not his prediction on the result, but his prediction on maybe what the critical issues are that are likely to be the focus of of oral discussion advocacy at the hearing on Tuesday. And with that, I'd just like to add as a preface, I mean, was domestic violence even a crime, you know, during the framers? I mean, was it a crime for a spouse to beat his spouse, a female wife? And if not, then apparently there's no history or tradition that would restrict or ban the use of a firearm by such person. And then we turn to the next issue, which is, well, what's the analog? Is there even any analog that we can turn to? And if there's no analog, then I guess the government loses, and Rahimi wins. I mean, is that what's likely to happen?
Well, if I had to make a prediction about this case, I've kind of been all over the place on it. I do think that the justices are less concerned with some of the issues that we've talked about here than we think. The Fifth Circuit would never have struck down 922G1, at least definitely not as to a violent felon. The Fifth Circuit didn't hesitate a whole lot on 922G8, perhaps because of the context in which it was enacted. But you know, I've kind of got to get outside of my kind of liberal brain thinking about, well, no one could possibly go along with this, and recognize there's people in the U.S. Supreme Court that think a lot like the people on the Fifth Circuit. I'm not saying it's a good thing at all. You can make up your own mind on that. But they're going to do it, whether we win or lose, they're going to do it in a way that protects felon in possession. Of that I'm confident. And it may be that you have to have kind of a weird coalition in the majority that it might even require having Rahimi win to then limit, probably in a concurrence, the test of Bruen in order to protect felon in possession. I think there's a couple ways of doing it. I think one of the obvious dials that everyone's talking about is degree of abstraction when you're looking at historical analogs. They can always turn that a few notches one way or a few notches the other, saying they're not changing Bruen, but they're clarifying Bruen, right? I think this is all going to be couched just clarifying, just how Bruen clarified Heller, which didn't answer any of these questions, right? The other thing they could do is say that we're clarifying that law-abiding is part of the test. Bruen, all of the cases talk about that concept. It's hard to know what to do with it because when Bruen articulates its test, it's not part of it. But it can't kind of just be doing nothing in those opinions. And so that's a difficult question. They could clarify that law-abiding, and then they could do so in a way that say, even if Rahimi wins, we're kind of defining law-abiding as if you've been convicted of a felony, then you're definitely not law-abiding. However else we're going to define it, we know that's on one side of the line. So I actually think I'm more optimistic than my colleagues on Zaki Rahimi prevailing. I think what's the elephant in the room, and I know we're talking about domestic violence, that's not a statute that's used hardly at all at the federal level. But the elephant in the room is felon in possession. That's what every question the justices ask, that's what they're really asking about. And I think they're going to protect it. I think Alito might not care about G8 at all. I think he really cares about felon in possession. And so I'm just very curious as an observer to see what happens.
I'll ask Jason and Kelly if they want to comment.
Well, the two notes that I wrote were things that Professor Beck just wrote, or just said, but I really, for me, I think the huge part of the game, let me take one time out. I forgot one thing to say in my official remarks that I do have to say under departmental policy. I forgot to say that I'm here in my individual capacity, and that anything I say doesn't necessarily represent the department. So thank you for giving me that opportunity. But I think the real money is on the law-abiding versus non-law-abiding. And if you read the Solicitor General's brief, they talk about how, hey, in every other opinion, you mention the word law-abiding as if it has some sort of term of art. Please mean what you say. Please mean that there is that divide between yes, we can regulate those who are not law-abiding. Now, but that raises a very interesting question, and I would love to have people's reactions to it. You know, do we know of any other constitutional right that works that way? In other words, you know, think about First Amendment issues. You know, do we have somebody that's a prior felon that they can't speak on certain issues? You know, does that translate to other constitutional rights? Yes, there's sort of the limitation on voting. So yes, there's kind of some semblance of that going on, but it would be a very unique thing, I think, to reach that result. But maybe they do, and I know the Solicitor General is pushing for it, and I think what we saw in Daniels was, as soon as the law-abiding part falls down, and in Daniels they rejected that, once you get into the historical test, there's just a paucity of historical analogs there, and so it just falls down. So I think the big money is on, does law-abiding mean something, or does it not?
Kelly?
I'm sort of scared to make predictions. I don't want to be too optimistic, and I don't want to be too pessimistic, but I do think there is an opportunity to sort of determine where law-abiding plays into this. I think it's very troubling, perhaps, to make a distinction between criminal convictions, which are permissible to regulate firearm possession, versus civil actions where it's impermissible. And if you look to many of the historical laws that the government cites, that we cite, they're not necessarily criminal. So like prohibiting people who refuse to swear oaths of loyalty, those weren't people who were convicted of crimes, but they were found to be people who could be disarmed. In the same way that people who were subject to surety statutes would have firearms regulated, despite that being a sort of civil criminal process. You know, not being an historian, I will borrow from somebody who is, and perhaps risk being corrected, that there wasn't sort of the same bright line distinction always at the time of the founding between civil and criminal, sort of a lot of hybrid interactions there. But then also, from a practical standpoint, a really troubling idea that, you know, as the Fifth Circuit says, instead of a restraining order, we should be prosecuting and incarcerating everybody. You know, if the Zaki Rahimis of the world are that bad, shouldn't we just be locking them up? Which, I mean, I think civil restraining orders, particularly in the domestic violence context, play a really critical role. You know, prosecutions can take a while. What do you do in the meantime? And that time of separation is oftentimes the very most dangerous as people are preparing to leave, to get out from under the immediate control of an abuser. And so this is not necessarily a Bruen argument or a historical argument. I just find it personally very troubling.
Okay. Actually, I think I'm going to hold off on my second question. We've got a little over 15 minutes left for this panel, and I want to make sure that there's plenty of opportunity for the audience to ask questions. So let's begin. Go ahead. And why don't you state your name and maybe where you're, you know, who you represent, and then is the question for any one member of the panel or for all members of the panel?
I'm Christina Mulligan. I'm from Notre Dame Law School, and I would love to hear the practitioners weigh in on a disagreement I had with Rob last night at dinner, which was, we were talking about how I was saying, you know, and then Bruen says you got to find an analogous statute, and Rob says no, it doesn't technically say that. It says it needs to be consistent with the historical tradition, and so you don't absolutely have to find an analogous statute. And I think, sir, my sense is that universally everyone has read it as though you have to, and so from the practitioner point of view, I'm curious if, in your view, it is required by Bruen or not.
Does analog require a statute or just a ban or prohibition, even if it wasn't codified in statute?
So I very much enjoyed your paper, by the way. I just wanted to comment on that. And I share many of your, I was persuaded by many of your critiques of originalism and how it kind of excluded certain voices. I don't think it requires a statute. I think kind of the form of originalism that it seems like Bruen is latching onto is what really matters is what the text of the Constitution says, and then we look to other sources to either confirm or reject a presumptive interpretation of that text. So that could be done in the form of laws, right? But then we would still need to know, even then, how those laws were enforced, how often they were enforced, kind of like some of the work some of the other folks were doing. That can be done also in the form of debates that happened. I think debates were certainly cited multiple times by the government. Even in their reply, a new debate I hadn't seen before in Congress. That could be in the form of even speeches, anything that reflects an understanding of what the scope of this right was at the time to either confirm or reject what the text seems to say. That's what I think Bruen requires. I don't think it requires a specific statute, but who knows? I don't have any confidence in anything I say, by the way.
Could common law serve then? Is that check and balance? Is that?
I think certainly.
I think it could as well, right? Yeah.
It could. I'll just say, from my experience, for most of the judges, they require a law. Debates are all fine and good, but they say, well, look, you debated it, but somebody voted on it, somebody enacted it, that I can get behind. It's interesting.
Yes, sir.
My name's Tony Hockel. I'm from the California Department of Justice. I was wondering if anyone on the panel had an opinion as to whether it's better, from your perspective, to be litigating these cases in the context of a criminal action, like the Rahimi case, or like a straight-ahead civil lawsuit, like brought by an interest group, for example, again challenging the constitutionality of a state statute or a federal statute.
Like for the NRA, for example.
Yeah,
the
so
NRA's bringing the
I'm
lawsuit.
just struck by,
Yeah.
so I'm here with my colleague, Chris Rosenberg, and we have like 46 active Second Amendment cases in California that we're dealing with, and they're all civil lawsuits where there are individual plaintiffs or often interest groups or gun dealers or manufacturers. Those are the plaintiffs, and we are the defendant. And that creates a very different dynamic and a very different day-to-day situation as compared to Mr. Medinger, prosecuting a case where someone like Mr. Beck is defending the defendant and challenging the regulation. Is it better to make inroads for your position in one context versus another? I don't know if you've ever thought about that.
I'll give my perspective very quickly. We have a lot of tension at the Federal Public Defender's Office with kind of the gun libertarian groups.
I was wondering about that.
They're very distrustful of how we approach because they rely on the good guy with a gun versus bad guy with a gun distinction, and that's a distinction that we have to disrupt. The civil folks are the ones who win in the cases, almost always. So you look at Heller, you look at McDonald, you look at Bruen, those are civil people with guns, and that's a more sympathetic litigant. The criminals are unsympathetic, at least before Bruen, couldn't win anything on these types of things. And so, me personally, I have no dog in the fight on the civil stuff. I think I take the position, my personal position is that firearms are under-regulated and over-criminalized, right? Which polls at like less than 1%. It's kind of like being...
You're not going to run for office on that.
Yeah. It's like being for the war but against the troops, kind of. Anyway, I want to represent people who are facing the most severe penalties. I'm not going to shed a tear for someone who can't have an AR-15 in their living room. I worry about the person who lives in a high crime area, whose pretext stopped, who possesses a firearm to defend themselves because they believe like they have to, and then they end up in jail for up to 15 years. Those are the people that I think are suffering in this context. Now, there's enormous suffering that happens elsewhere with mass shootings and things like that. I'm not discounting that. I'm saying when I compare the civil person who wants to be able to have an automatic machine gun because it's fun versus someone who's going to jail for a long time, I have more sympathy for the person going to jail. So the civil people win, the criminal people don't, but I would not want to, I wouldn't represent a civil person. It's not interesting to me. I don't think there's anything at stake for me.
Anyone else want to comment on that question?
Just briefly, for me, I don't know if I have a dog in the fight. I just want clarity in the law. I think that is, as a civilization, as a society, we are all citizens here. Everybody should know what the rules of the road are. You know, I care so much about our system of laws and our society, and I just think it's hard to exist when people don't know who's on first. And the quicker we get there, whether it's civilly or criminally, it actually doesn't matter to me. At bottom, I just want to get to a point that we can all agree on and move on as a society as to what we want, what rules we want to govern ourselves.
Next question.
Yes. Robert Leiter, George Mason University. One of the things about Bruen and Heller is they haven't disrupted large swaths of area. So prosecutions under the National Firearms Act are going forward. There's no question that you can enhance sentences for using a gun, crime of violence. The things that seem to be under most tension are the possession prohibitors, which are also the things that are most constitutionally problematic because they ban possession in the home. I mean, just total ban on possession. And I'm wondering, I'm just curious for your comments on this, more of a comment that I'd be curious for your feedback on. I think in some ways it reflects what has become the criminalization of crime prevention. Because when I talk to people who are in the criminal law space, especially prosecutors, their fears are always, well, you know, we don't want to wait until either a crime has been committed or even an attempt has been in progress. That what these laws do are let us intervene in the cycle of violence very early. And so for prosecutors, they tend to be very useful from that end. But you know, in the old days, you had sureties, you had things that were either not criminal or quasi-criminal ways of handling crime prevention. It seems now that we've turned to a model of crime prevention with a bunch of inchoate crimes that are themselves extremely punitive. And I'd be curious for your thoughts on that.
I'll answer that one.
I've talked to that.
Yeah, I guess for me, I'll just speak as, you know, my perspective comes from the executive branch, and I am here to execute the laws. I feel like that's a great question for our legislature. And to say, like, you know, is that actually an effective legislative response to a public safety issue? And in my view, if the legislature say, no, that one's off the books, no skin off my nose, there's plenty of other things in the federal code to enforce. But I see your point that, you know, is that the right thing? I will say we do use it as you described. We do use it as a tool. I'll say, like, you know, we mentioned the MS-13 individuals. You know, those are often inroads to, you know, get people with charges. Maybe they decide to cooperate. Maybe that gets you further into larger crimes. So in some respects, it can be a doorstop into, you know, larger issues. But like I said, but for me, I think ultimately it's a legislative call, and if they decide that's what should be done, then I'll prosecute that.
Can I ask why on that one? Because there are a lot of crimes federal prosecutors don't enforce.
Well, I think
Why is this a legislative?
Well, I'll say, like, I think we at least try to enforce, you know, all the ones that we see. There's certainly ones that, you know, we see more often and that we charge more prevalently. But, you know, I'm of the belief that if it's something that's on the books, you know, we should be enforcing it when and if we can in our prosecutorial discretion.
This may be related to your question. So on the preventive side, you know, we want to have these gun laws to prevent, it's a matter of policy to prevent bad things from happening. So I think one of the next critical challenges that's going to come up under Bruen is the red flag laws. And so are red flag laws going to be able to withstand scrutiny under Bruen? I mean, again, if we apply this test of looking at the historical the history of gun control, is there an analog with respect to banning weapons from people that suffer from some mental illness or mental disability? You had commented, Cully, you know, that from a policy perspective, you know, this is good policy, right? I mean, isn't it good policy? I mean, we actually permit individuals to be not saying locked up, but certainly detained, right, based upon involuntary detention if they pose a danger to society. But apparently those same individuals cannot be prohibited from possessing a gun under Bruen. I mean, that strikes me as being inherently inconsistent. But again, there is a Second Amendment that applies in the gun possession case. So what's your sense of how Bruen what the outcome on red flag laws would be following the framework in Bruen?
Well, I'm gonna say the thing that makes most people groan when I say it, which is, it depends on a number of different factors. But before I get into that, I do wanna say one thing about the extreme risk protection orders, which is they are not meant to be either exclusively or primarily a tool to address people experiencing mental illness. It's meant to address people who are dangerous to themselves or others for any variety of reasons, whether that be suffering from mental illness or a lot of different things. I think the extreme risk protection orders are maybe unique in the space of gun violence prevention in that they address a wide array of different harms, including self-harm, interpersonal violence, as well as mass shootings. They are primarily used for the prevention of suicide, but there is a growing body of research showing that the orders are sought based on threats of mass harm, so threats primarily to K through 12 schools. It's almost like you'll have to do a couple of different parallel tracks for historical analogies for suicide prevention, but also historical analogies for the prevention of interpersonal violence, which I don't think is terribly that different from Rahimi in one respect, but somewhat different in a different respect. And to go back just a little bit and get on my soapbox, because why not? In terms of crime prevention, I don't necessarily think of the domestic violence protective orders as being particularly early down that road. Many studies show that by the time people are seeking protective orders, they've already experienced incredibly severe abuse. There's studies of women seeking protective orders who have experienced extreme violence like choking, strangulation, severe physical abuse. And so this is ultimately, in my mind, to prevent lethal violence at this point. And so that doesn't answer your original question, but I think, again, it depending on the level of abstraction, how closely. Obviously, there were no extreme risk protection orders at the founding. I think we use the word innovative to describe ERPOs in almost every single thing we put out at the Center for Gun Violence Solutions, which isn't doing us a whole lot of favors right now. But I think the broader term goal, I don't think is dissimilar from a lot of the goals of historical laws.
Yes, sir.
It's Daryl Miller. So one of the things about the Rahimi case that I talked with my colleagues and during lunch that perplexes me is like, what's so special about the gun? So imagine you had a scenario where instead of having as part of the restraining order, you can't come within whatever, a mile or 100 feet or whatever of the person, or you can't see kids, or you can't call them up, or you can't do that. You just had a separate standalone statute that did the same thing. Just made it a crime to do these things. And then you have a process to figure out whether somebody is going to be subject to a restraining order, but the criminal penalties are out as a freestanding statute. That strikes me as exactly what this prohibitor does, right? You have a process, and then you have a freestanding thing sitting out there that says, now you can't have a gun. Now, it's not, you can't have any weapon. I'm assuming you can still have a club, you can have kitchen knives, you can have whatever, it's just you can't have a gun. So what work is the Second Amendment and the part of this case actually doing other than making it constitutionally safe? Because it feels like we adjudicate a bunch of other kinds of rights, substantive due process rights, First Amendment rights in the DV context already. What am I missing?
Well, I'll go unless somebody wants to go.
You first.
I hope this may not answer your question, but I'll give my best shot at it. If there was a domestic violence protective order that said you can't come within shooting distance of the applicant. So the goal here is to protect the person that's the survivor of domestic violence. And the way we're gonna do so is if a gun can shoot a mile or whatever, you can't come within a mile of that person. I think the Second Amendment gets implicated, at least under Heller and McDonald, when the prohibition extends to possessing a firearm in the home for purposes of self-defense. So there are examples where someone has a domestic violence protective order, moves literally to another state, and is then prosecuted federally for possessing a firearm in their home. That's where it kind of, the Second Amendment really comes more into play for me. I know Bruen extended that outside of the home, and that does complicate things. But I think a protective order consistent with even Rahimi winning could prohibit a firearm in the proximity of another individual who is an applicant for a protective order.
I think we have time for one last question. In the back, yes. Get a little louder, we can all hear it from.
I'm just a 2L here at the law school. This question is addressed to the whole panel, but I think Mr. Medinger might not care as much because I think for this question to matter, you have to think that you can go beyond just a direct historical analog with the Bruen analysis. So assuming that you can do that you can do something akin to what Professor Beck suggested or what I think Professor Vogt kind of alluded to, where you could you would look to the reason behind it. You say, oh, it's protecting from dangerous individuals. You have to check. There's a historical precedent for like dangerous individual regulation, and you look at 920 UG in light of that. And if you're doing that, do you have this thing where it means an analysis kind of becomes a problem again? It sort of slips back into because everybody's kind of characterized it like, oh, we're done with the means and analysis, now it's a historical analysis. But then if your historical reason is like, say, dangerous individuals, then the statute becomes a proxy for like finding the dangerous individuals, and then you can easily see scenarios where it can be a very broad statute, namely if you have any sort of restraining order, then you don't have the right to a gun, or it can be very narrow where you have to do an individual analysis for each criminal defendant in the prosecution and see like, are you really dangerous? And then it seems like there's sort of another means analysis where you're like, is the statute narrowly tailored to the interests that we have, even though it's sort of a historical analysis. So like, do you guys think that we're done with means end, or do you think it'll sort of sneak in again, even inside the like, Bruen historical context?
Do you want to go, or do you maybe?
Kelly, do you want to say?
Could be anybody. I mean, I think it, in some ways, yes, maybe like a means end light. Because again, I'm not completely sure that Bruen is really fussed about whether it works, which was a really big part of the analysis under intermediate scrutiny and strict scrutiny. It was how closely was it fit to achieving this purpose. Now I think we're left solely with how it's done and why it's done. And so that's been a big question about the courts, is how do you determine if the touchstone of constitutionality is dangerousness, how do you determine today who is dangerous, and how much deference do you give to legislatures to determine who is dangerous? I mean, I think if you look at some of these historical laws, many of them were categorical proxies, right? People who refused to swear oaths of loyalty. Not necessarily an individualized assessment. And interestingly enough, the first version of the Fifth Circuit's opinion especially eschews this idea that an individualized assessment is appropriate in this context. They replaced it, I think, because of a lot of well-deserved criticism of that particular passage. But from our perspective at the center, I think that's exactly the place that public health research returns to the analysis, is determining who is dangerous, and maybe that's appropriate on a categorical level. Maybe the court will decide you need to have an individualized assessment, in which case perhaps in Rahimi what we'll see is an upholding of most but not all of 922G8, keeping the protective orders where there's this credible finding of threat, of danger to the intimate partner or their child, but not necessarily orders that just include these prohibitions on this type of activity. It's up in the air, everything else.
Let me just just real quick, we're going to wrap up here in about 2 minutes. So any additional response?
Well, I think, means and scrutiny may come back. I mean, the government spends a good amount of its briefing, the amici spend a good amount of their briefing, speaking very accurately about the societal problems today that domestic violence, domestic gun violence presents. That's very, very true. But it's only really true, it only really matters in a means in scrutiny, right? When you're weighing the degree of governmental interest, for example. So to the extent at all the court latches on to some of that as persuasive, I think it will reincorporate some means in scrutiny to the analysis. Bruen, at least the Thomas opinion in Bruen, says none of that matters. I assume there are other justices on the court that may have even gone along with that do think it matters. So to the extent that I'm right in predicting that Rahimi will be approach narrowing the Bruen test, that's one way it can do it, again, to clarify and say we're not really doing means and scrutiny, but I think that's what it is when you start weighing the degree of the governmental interest.
Jason, you want to add anything? Last comment.
No, I'm good.
Okay. Okay. Then I would like you to join me in thanking our panelists for very rich and very stimulating and interesting discussion.